Hello everyone, welcome and welcome back to my channel. I am Neha and today in this video I am going to discuss essentials of a valid contract. So, as given by section 10 of Indian Contract Act 1872 and the secondly not given by section 10 but considered essential of for a valid contract. So let's start with the section 10 as given by section 10 of Indian Contract Act 1872. For having a valid contract, what are the essentials which are present for valid contract? The first one is agreement, because we see the definition of contract. In that definition we see that an agreement enforceable by law. So the first essential is agreement. Second is free consent. We will discuss in detail after that. Competencies of the parties, lawful consideration, legal object not expressly declared to be void. These six essentials are given by section 10 of Indian Contract Act 1872. Not given by section 10 but are also considered essential. Firstly, two parties, intention to create legal relationship, because an agreement enforceable by law is a contract. If there is no enforceability, there is no contract. So second is intention to create legal relationship, fulfillment of legal formalities for creating legal relationship. Fourth, certainty of meaning. Fifth, possibility of performance. So which is not given in section 10. These are five essential which is not given in section 10 but considered essential for becoming a contract. So let's start with the first one, two parties. A contract involves at least two parties, one party making the offer, because we see for having an agreement there are two parties. The first who is offering and the second who is accepting. So a contract involves at least two parties, one party making the offer and the other party accepting it. For example, to constitute a contract of sale, there must be two parties. If you are doing a contract of sale, then there are two parties. First one is seller and the second one is buyer. The seller and buyer must be of two different persons, because a person cannot buy his own goods. So there must be two parties for a valid contract. Second, parties must intend to create legal obligation. For becoming a contract, we see an agreement enforceable by law. It means to create legal obligation. So, for example, a husband agreed to pay to his wife certain amount as maintenance. So here we see about husband and wife. So a husband agreed to pay to his wife certain amount as maintenance every month while he was abroad. Husband failed to pay the promised amount. Wife sued him for the recovery of the amount. So here in the case, wife could not recover as it was a social agreement. In previous video I also convey that if there is a father and son relation, husband and wife, these are social agreement. This is not a contract, because here the legal intent, because here intention to create legal obligation is lacking. So it is a social agreement, and if it is a social agreement, it is not a contract, it is just an agreement, and the parties did not intend to create any legal relation. Next example, Lekpal promises to pay rupees 5 lakh to his son. Here father and son relationship, it is also a social agreement. So here there is no intention to create legal obligation. Lekpal promises to pay 5 lakh to his son if the son passed the CA exams. On passing the exam, the son claimed the money. Here the son could not recover as it was a social agreement. Next example, as A sold goods to B. There are two parties, A and B. Here A is selling the goods to B on a condition that he must pay for the amount of goods within 30 days. So here there is a consideration also, and consideration are the most important thing for having a contract. If there is no consideration, there is no contract, but there are certain exceptions also. Here A intended to create legal relationship with B, hence the same is contract. On failure by B for making a payment on due date, A can sue him in the court of law. Okay, next, other formalities to be complied with in certain cases. It means, for example, other formalities to be complied with in certain cases. For example, contract of insurance is not valid because except as a written contract. Further, in case of certain contract, for example, registration of contract under the laws which is in force at time is essential for it to be a valid. So there are other elements in which there is one element that other formalities to be complied with in certain cases. For example, contract of insurance, immovable property, in case of immovable property. Okay, certainty of meaning. If the meaning is not certain, there is a uncertainty, vague, then it is not a contract. The agreement must be certain and not vague or indefinite. For example, A agreed to sell to B. There are two parties A and B. A is the seller who agreed to sell to B 100 tons of oil. There is nothing certain in order to show what kind of oil was intended for. Then it is not a contract because there is no certainty which kind of oil, here not expressed it. So it is not a contract because there is no certainty, it is a vague. Okay, next, another example, XYZ Limited agreed to lease the land to Mr. A for indefinite year. Here the years are not mentioned, indefinite years. The contract is not valid as the period of lease is not mentioned. Possibility of performance of an agreement. If there is an impossibility of performance, then it is not a contract. The terms of agreement should be capable of performance. An agreement to do an act impossible in itself cannot be enforced. For example, A agree with B to discover treasure by magic. So the agreement cannot be enforced as it is not possible to be performed. Okay. So these are the essential which are considered important but not given in section 10. Now come to the another part which is given in section 10 of the Indian Contract Act 1872. So what are the essential elements which is given in section 10? Let's discuss. The first is offer and acceptance or an agreement. Yeah, this is important because what is agreement that we see in previous video. So when we define contract, what we convey, we say an agreement enforceable by law. If there is no agreement, can there be a contract? No. It is essential for a valid contract to have an agreement. So here the first is agreement. An agreement is the first essential element of a valid contract. And in previous video I discussed how to remember section. So section 2 clause E of the Indian Contract Act 1872, every promise and every set of promises forming consideration for each other is an agreement, and according to section 2 clause B, a proposal when accepted becomes a promise, and agreement is an outcome of offer and acceptance. Second is free consent. Consent must be free. If there is no free consent, then it is not a contract. For example, and yeah, consent would be, what do you mean by consent? Consent would be considered as free consent if it is not caused by coercion, undue influence, fraud, misrepresentation or mistake. It means you can't obtain the consent by forcefully. Okay, and the term, there are 5 terms which is given: coercion, undue influence, fraud, misrepresentation or mistake. We are discussed in detail in later part of the videos. Okay, so let's discuss one example. A, who owned 2 cars, is selling red car to B. A is a seller. Here in this A who owned 2 cars. Okay, and A is selling red car to B. B thinks that he is purchasing the black car. So here there is a confusion that A is selling red car, but B think that he is purchasing the black car. There is no consensus aid idiom and hence no contract. Okay, so here there is no consensus aid idiom. Okay, so because so that it is not a contract, because you can understand that identity of minds. Okay, one person say something and another understand something, so there is no consensus aid idiom. This can also be understood as identity of mind in understanding the terms. Next example, A threatened to shoot B if he does not lend him 2000 and B agree to it. So here two parties, A and B. Now A threat to shoot B if B does not lend. So guys, here it is a coercion. Here the agreement is entered into under coercion and hence he is not a valid contract because the consent is not free. On the gunpoint he asked to lend, so it is not a contract. Capacity of the parties. Section 11 of the Indian Contract Act specifies that every person is competent to contract who is the age of majority according to the law to which he is subject. It means 18 year of age. Okay, our person below 18 year of age are considered minor and he is incompetent, but 18 or more it is capable of contract. Second is of sound mind and is not otherwise disqualified from contracting by any law to which he is subject. So there are 3 essential things which is given. Next is consideration. It is very important. Latin terms, it is known as quid pro quo, that is something in return. If you are selling something, you are getting something. So this is a consideration. If I am selling a car, then you are purchasing with rupees whatever. Okay, so this is a consideration. A agreed to sell his books to B for ₹100. Here A agreed to sell to B for ₹100. So first is books and second rupees. So there is a consideration. B promises to pay ₹100 is the consideration for A promise to sell his books, and S promise to sell the books is the consideration for B promise to pay ₹100. Next is lawful consideration and object. The consideration and the object of the agreement must be lawful. If unlawful object, then it is not a contract. For example, A promises to drop prosecution instituted against B for robbery and B promises to restore the value of the things taken. The agreement is void as its object is unlawful. Okay. And what is void and voidable? I am discussing in my lecture. You can search out difference between void and voidable, or you can search for valid and void. Okay. Next example is A agreed to sell his house to B against 100 kgs of drugs, cocaine. Such agreement is illegal as the consideration is unlawful. Not expressly declared to be void. If it is declared to be void, then it is not a contract. The agreement entered into must not be which the law declared to be either illegal or void, because illegal or void is not a contract. Threat to commit murder or making publishing defamatory statement or entering into agreement which are opposed to public policy are illegal in nature. Similarly, any agreement in restraint of trade, marriage, legal proceedings, etc. are classic examples of void agreement, and in detail we understand what is void, valid, voidable. Okay, so here in this video I explained the essential elements of a valid contract. In next part we will discuss types of contracts. So I hope you enjoy this video. Thanks for watching.